Good morning, everyone, and welcome back to our weekly webinar series. We're today continuing the topic that we were taking up last time. We are, of course, discussing the part two with respect to resolving insolvency, where ED and investigative agencies are also involved in the whole process. Over to Anil.
Thank you, Ankit. Welcome to 107th episode of AAA weekly webinar series. This is part two of the subject that we deliberated last Saturday in our 106th episode. So in the last episode, we discussed about PMLA law and the detailed analysis of the judgment of Vijay Madan Lal Chaudhary from Honorable Supreme Court, where most of the provisions of PMLA was held as valid and constitutional. And before that, even there was another judgment from Honorable Supreme Court that was in the case of Manish Kumar, that was basically for the constitutional validity of Section 32 capital A, which was inserted in IBC just to protect the insolvency and resolution of those companies where the resolution plan has been approved or the assets have been sold under the liquidation process. After that, there was a protection given to the successful resolution applicant or a successful buyer. The only conditions were that those buyers, one, that there should be change of management. Two, the new management should not have any role in the charge sheet of the corporate debtor. So they should not have any mention, or mention means they should not be accused in the charge sheet. So these were the analysis done in the part one. And today we actually would be focusing on various judgments where the assets are attached by either Enforcement Directorate under PMLA or Enforcement Directorate under any other law, such as the protection of MPID, means the Maharashtra Protection of Depositors kind of act. So we actually would like to continue with our discussion in the IBC. So in case we try to analyze at the beginning of this, there are controversial judgments. And the judgments primarily can be categorized into three parts. One, those cases where the assets were attached before the commencement of insolvency. Second, where the assets were attached during the CIRP or during liquidation process. Three, where the assets are likely to be attached or being attached or attached after the resolution plan has been approved by adjudicating authority or the assets have been sold conclusively. So these are the three broader categories of the various cases under the various forums in India where the IBC and PMLA are clashing between each other. And of course, one, whether this moratorium under Section 14 of IBC is applicable to those cases where the assets are attached by Enforcement Directorate. So the first, we will start with the kind of some kind of light that we can see in all these cases. Although I understand that this case also will finally be tagged along a very big bouquet of cases before Honorable Supreme Court. So this case, in fact, which was delivered by Bombay High Court on 1st of March 2024, the name of the case is Shiv Charan and others versus adjudicating authority under PMLA. The judgment has actually been given by Justice B.P. Kolabawala and Justice Somashekhar Sundaresan. So basic law point which was identified by the Honorable High Court was whether the NCLT has the jurisdiction to direct the Enforcement Directorate to release the attached assets, whether the NCLT has the jurisdiction to direct the Enforcement Directorate to release the attached assets, and whether the corporate debtor can be protected by invoking Section 32A of the IBC. Now, this was the judgment, and in fact, we would not be able to do a detailed analysis of various other judgments, but this judgment I would like to give a detailed analysis. The facts in this case was that there were two orders were passed by the adjudicating authority. One was for the approval of resolution plan, and the other was directing the Enforcement Directorate to release the attached properties in favor of the successful resolution applicant. So there is a slight difference in this case as against many other cases. In this case, the resolution plan has already been approved by adjudicating authority, and therefore the Bombay High Court passed an order. However, the Section 32A also says very clearly that there should not be, in this case also, there was no, there was a definite change of management, and there was no connection between the accused and the buyer. So therefore, this Bombay High Court, in fact, the facts were basically before the even CIRP started, FIR was filed against the CD, and an enforcement case investigation, like the ECIR, enforcement case information report was already filed, it was already prepared by the Enforcement Directorate under PMLA. So there were some bank accounts, there were some 14, 15 flats, those were also attached by the Enforcement Directorate, and two writ petitions were filed in High Court, one by the successful resolution applicant seeking quashing of the Enforcement Directorate's order of attachment, and also the invoking Section 32A, and basically the dispute was whether the adjudicating authority has the power, and that ED also filed an application. Two writ petitions were filed, and the arguments by the ED was that the assets were attached prior to commencement of the CIRP. Second, that the adjudicating authority does not have power to go beyond the ambit of IBC, and dealing with the issues of PMLA is not within the powers of the adjudicating authority. Then the also Enforcement Directorate was also kind of arguing that the successful resolution applicant has other alternatives as provided under the PMLA, like appellate tribunal, which is called appellate tribunal under SAFEMA, or appellate tribunal under PMLA, whatever you call maybe. Then a special court under PMLA. So this was the argument of the Enforcement Directorate. Successful resolution applicant clearly invoked Section 32A of the IBC, and also that the attachment by the PMLA is an interim measure, and that is not final, and the confiscation of the property and proceeds of crime, all there is a complete protection to successful resolution applicant under Section 32A. Therefore, finally the court in fact decided, one, yes, there is a adjudicating authority has complete jurisdiction to declare that the corporate debtor is discharged from the offenses alleged prior to CIRP, and to order the release of the attached properties upon approval of the resolution plan. This is a clear power available with the adjudicating authority. Then, secondly, Section 32A of the IBC provides immunity to the corporate debtor from prosecution, and this protection attends to its properties also. This protection extends to its properties also. The court emphasized that this immunity is available only when there is a change in control and management of the corporate debtor through the approval of resolution plan, not otherwise. So then the court referred the Supreme Court judgment where this, in the case of Manish Kumar versus Union of India, where the uh, Section 32A was held constitutional, and therefore the any action taken by the corporate debtor before the approval of the resolution plan, the new management was completely protected. That was the constitutional validity of Section 32A in the case of Manish Kumar. Then, of course, the once the conditions under Section 32A are met, once the conditions under Section 32A are met, that actually means that further prosecution against the CD or its properties ceases. So this judgment, in fact, is a new light, I hope, amongst all these cases. So what we understand that this judgment also would finally be appealed. There will be appeal. According to our understanding, the Enforcement Directorate will file an appeal against this order of Bombay High Court, and finally it will tag along. Already there are 9 cases tagged along together before Honorable Supreme Court, and this also will stand tagged along before the Supreme Court. Now, this is the only judgment. Before that, there are judgments in the case of Varsana Ispat, which is my case where I'm personally the liquidator, and that in fact the Supreme Court has held that the liquidator cannot be benefited or cannot seek benefit under Section 14 when the properties are attached by the Enforcement Directorate even before the commencement of CIRP. And in another case, which is where I am the liquidator, Rotomac group of companies, where the matter is pending and it is tagged along with 9 other matters of similar nature. So those matters are pending. However, the Supreme Court has not given any decision on one, whether the adjudicating authority has the powers to direct Enforcement Directorate. Number 2, whether 32A is applicable on what kind of cases. Is it possible that even if the properties are attached before the commencement of CIRP and then resolution plan is approved, or assets are sold to a person who is not the same management, so there is a change in the management. So after even complying the conditions under Section 32A, whether the sale would be possible or not. So this Shiv Charan case is very, very unique case where the RP went for the resolution plan while the assets were attached. The resolution plan was approved by the adjudicating authority while the assets remains attached, and it was also before it was approved by the committee of creditors. So therefore, it was a kind of proactive actions by the RP. I duly attached assets was in fact put on a resolution plan. Resolution plan was approved by a committee of creditors, and finally this order from Bombay High Court that actually shows the applicability of 32A. Even if the assets were attached before the commencement of CIRP, the resolution plan was approved, there was change in the management, and the successful resolution applicant has no kind of concern or no inclusion in the charge sheet as accused. Therefore, these conditions were approved. So the Bombay High Court passed an order about the authority of the adjudicating authority and the uh, applicability of Section 32A to such cases, even if the assets were attached before the commencement of CIR. Now, there are many judgments. Let's see, I can even, there are other judgments like I would say in our own case, Nitin Jain, the liquidator of PSL Limited versus the Enforcement Directorate. That is a judgment from Delhi High Court. In that judgment, the liquidator and the committee of creditors and the Enforcement Directorate. So what was the case? The company in the assets were attached by the Enforcement Directorate. during the liquidation. And in fact, while the sale of the company as a going concern was also completed to the extent that the auction was completed and some part of the money was received. The balance was not received. At that particular time, the assets were provisionally attached by Enforcement Directorate. However, the total value of proceeds of crime in the charge sheet was lower. It was only 270 crore. And the assets of the company, in fact, was slightly higher, rather much higher. So then committee of creditors and the liquidator, they asked the court that in case the liquidator is allowed to sell the assets, liquidate the assets, realize the money, and deposit the amount equivalent to the proceeds of crime, which is 270 crores, in interest-bearing deposits in a bank account in the name of Enforcement Directorate. Then the balance amount, whatever is realized, that will be distributed to the stakeholders under Section 53. This was allowed, of course, with the consent of the Enforcement Directorate. Enforcement Directorate also gave consent in this case, saying, yes, we also kind of agree to this. So that particular judgment has already been concluded. The assets have been sold for about 600 crores. Out of that, 270 crore has already been deposited in the bank as interest-bearing deposits in the name of Enforcement Directorate. Whenever there will be a decision, whether that actually is a proceeds of crime or not, if it would be proceeds of crime, it will go to the exchequer to go to central government. And if it will be held that it is not proceeds of crime, then it will go to stakeholders under Section 53. That is a judgment where, in the case of Nitin Jain, which we handled as AAA. So another judgment that we have seen from High Court, Chennai High Court, is when the assets were attached of a person, and in that matter, the assets were not fully owned by the accused, partly owned by the accused and partly owned by another brother or another person. So the other person said that the value of this asset according to your charge sheet is, say, X. I am ready to deposit the FDR or deposit the amount in your bank account as an FDR, and the asset may be handed over to me because I am suffering unnecessarily and I am actually trying to sell my asset. I am not able to sell because of the attachment of one part of the asset, and it is not possible to sell the asset individually or my part. So therefore, the court in fact said, permitted them that you deposit this much of amount, which is as per the valuation of that particular item. And in case you would do that, deposit that money in the bank account, and then we will permit. So court permitted that, also one of the very important judgment. So now we come down to the judgments of NCL80. In NCL80, in the case of Sterling SEZ Infrastructure Limited, the case name is Director of Enforcement versus Manoj Kumar Agarwal, the resolution professional, and the name of the corporate debtor is Sterling SCZ Infrastructure Limited. The date of the judgment is 9th of April 2021, and it is from NCL80, Delhi. Now, in this case, the appeal, in fact, has been filed by the Enforcement Directorate against the order of NCLT, where the NCLT nullified the attachment order issued by the Enforcement Directorate prior to the commencement of CIR. Prior to commencement, NCLT detached and the ED filed an appeal. Then NCLT also permitted the RP to take control and custody of the assets and directed the Enforcement Directorate to hand over the control and custody of the assets to RP. Now, the appeal, in fact, was challenging, and the ED, in fact, argued before, like the application was submitted, it was after the attachment, and the RP sought release, which granted. So the NCLT lacked jurisdiction, and the content that the introduction of Section 32A of the IBC does not affect actions taken before the approval of the resolution plan. So this is a kind of common a common view which is coming from the courts, that Section 32A would be applicable only after the resolution plan is approved and not before that. Section 32A would be applied and it would be effective in case the assets are sold under liquidation. Then the 32A would be applicable. So in this case, therefore, the moratorium is not applicable. That of course, is a kind of consensus in various courts that the moratorium is not applicable. And 238 also will not be able to say that like kind of PMLA is kind of uh, uh, is a superior law as against overrides IBC or IBC overrides PMLA. So there is a judgment in the case of Enforcement Directorate, Joint Director versus Axis Bank. In that judgment, Delhi High Court said that IBC and PMLA has to coexist. It is not possible to say that IBC overrides PMLA or PMLA overrides uh, the IBC, because both are basically with the different objectives, and both the objectives are still valid, and both the objectives are uh, independent of each other. Therefore, both the objectives have to be met together. It is not possible that we ignore one objective and we only kind of consider one law at a while. Finally, the decision of the NCL 80 was in favor of the detachment, and the basically the like the PMLA like attachment order issued by under the PMLA was null and void under Section 14, because it was applicability of moratorium Section 63, and again 238 was referred in the judgment, and therefore the RP has to take the control and custody. The PMLA is a special legislation. 32A actually is giving protection, and this particular judgment finally it was in favor of the detachment. Although later on there are many judgments from NCL 80 which are basically dissenting with this judgment. So no, the present NCL 80 judgments, the recent NCL 80 judgments are not relying on this Manoj Kumar Agarwal judgment in the case of Sterling SEZ Infrastructure Limited. If see, based on this particular judgment, there was another judgment passed that was in the case of National Spot Exchange Limited versus Namdari Food International Limited through its liquidator, and the name of the corporate debtor in this case was Namdari Food International Private Limited, and this judgment was also closer to the earlier judgment. This judgment was on 20th of September 2021, and it was from NCLAT. However, in this case, it was not the schedule of crime, although the assets were basically attached by the Enforcement Directorate, but it was attached. No, it was not attached by the enforcement. It was attached by Economic Offence Wing, and it was attached under Maharashtra Protection of Interest of Depositors MPID Act 1999, and in this case also the Section 14 was used, 238 was used, and the Maharashtra Protection of Interest of Depositors was also kind of protection of the creditors. So therefore, the objective of MPID and the objective of IBC was clashing. So therefore, this particular judgment that IBC overrides MPID. So in this case also, the assets were detached. The directions were given to the Economic Offence Wing for the purpose of giving the custody and control. So that was also a judgment in favor of detachment, in favor of supremacy of the IBC, in favor of moratorium and Section 238. Now we can go to another judgment, which is in the case of Kiran Shah, the resolution professional of KSL and Industries Limited versus Enforcement Directorate. This is also an appeal before the NCLAT, and the date of judgment is again 3rd of January 2022. And in this case, the attachment was done for about 283 crore. CIRP was initiated, and despite the IBC, the prosecution complaint was filed, provisional attachment was also given, and therefore the RP filed an appeal before appellate tribunal under PMLA, and the application before the adjudicating for setting aside the provisional attachment order. So NCLT Ahmedabad first rejected the application, prompting the current company appeal by this. In appeal, the discussion happened. So this was the first case where the NCLT, after the Manoj Kumar Agarwal and after the Namdari Food, this was the first case where the NCLAT dissented and said that the appeal, yes, it was. So the NCLT in fact lacked jurisdiction, and therefore the application seeking set aside the attachment of the property of the CD by the ED was dismissed by the tribunal. Consequently, this company appeal filed by the appellant resolution profession was also dismissed. So in this case, the NCLT, first time NCLT said that the company should be, it is not possible, it is not my jurisdiction to detach the assets. And the NCLAT also said the same thing. So Ahmedabad NCLT said that it is not possible, it is not within my power to detach. And the NCLAT also said that the appeal is dismissed, as the adjudicating authority is not having any power to deal with the such issues of PMLA, because the PMLA has a separate structure. Like there is an adjudicating authority, there is a appellate authority, appellate tribunal, then there is a high court, and then there is a Supreme Court. On the other hand, there is a special court under PMLA, and then finally again after the special court it will be high court. Now let us come to that particular issue. What all orders are pending before Honorable Supreme Court? Because we have seen the one judgment from Bombay High Court, which is in favor of IBC. Second, we have seen one judgment from Delhi High Court, which is in favor of powers of the liquidator to sell, of course, with the consent of the Enforcement Directorate. And we also have seen that in that case, it was permitted to the liquidator to sell the assets and deposit the proceeds of crime, accused or the proceeds of crime in the bank. Then in another case, we have also seen that some person was finding difficulty. So he was also told that you deposit that amount in the bank and you can sell your asset. So that the difficulty that we are facing because of the attachment of one half of it or one part of it, that actually the difficulty is removed. Now, there are 9 connected matters before Honorable Supreme Court, and these matters have basically the main matter which actually in which it started, and the main matter was State Bank of India versus Dr. Keval Krishan Sood and others, and Axis Bank Limited versus Deputy Director. The Axis Bank is Delhi High Court judgment. In fact, that was the first judgment which said that both laws have to coexist. The objectives of the both law, IBC and PMLA, are separate and they have to coexist. The objective of PMLA and the objective of IBC cannot be, neither it can be clubbed together, nor any one of these objectives can be ignored. So these two matters, in fact, 5 appeals were filed before Delhi High Court, and this was the order of Axis Bank versus Deputy Director. So the primary questions of law that actually we could see in this Axis Bank or State Bank in Keval Krishan Sood. So the primary question of law, where the properties involved in money laundering are subject to attachment and subsequent confiscation under PML. How should the conflicting claims of the state authorities to confiscate such properties and the lawful claims of third parties with legitimate interest in these properties, such as those arising from charges, liens, or encumbrances, be resolved? So the primary issue is that one, that there is a claim from the central government under PMLA that these properties belongs to the exchequer, belongs to central government. There is a second claim which is from the secured financial creditors or secured creditors who says that we actually have given loan against the mortgage of these properties, and these properties were acquired much before the proceeds of crime. These properties were acquired or even mortgaged much before the proceeds of crime as per the charge sheet. So these are the various questions which are actually pending before the Honorable Supreme Court. So in fact, the in the Axis Bank, in that case of Axis Bank, and in the case of Dr. Keval Krishan Sood, the High Court, High Court held that the attachment process under PMLA runs parallel to the criminal proceedings for money laundering. We already have seen the definition of money laundering is not just converting black money into white. The definition of money laundering is the uh, any kind of uh, possession, retention, use, laundering of the proceeds of crime. So, Ankit, we need to see whether there are some questions at this stage so that we can actually take a pause and try to see the questions if there are any.
So one question is that it is from Mr. J.K. Das. He says, after successful resolution where all statutory liabilities at the earlier promoters are fully extinguished, can there be a fresh claim by EPFO pertaining to the previous period under Section 7A of the PF Act? That's first one question of his. Second question of his is any relevant judgment of NCLAT High Court or Supreme Court. So here, this is Jitendra Kumar Das, who's an insolvency professional. So what I understand out of this question is that, of course, this is a different question as compared to what is the topic of the day. But EPFO, if they file the claim within whatever 90 days, that is the permitted time, or maybe after also, then they get a priority for payment as per the Supreme Court ruling. And there are plenty of judgments there. We can share that offline. And if they don't file a claim, then of course one can say that the claim was never filed and a fresh claim after the resolution plan approval cannot be entertained. So this
There
is
was there
my
was a judgment, even very strong judgment, that in case the PF officers are not able to file their claim, and in that particular judgment, I believe it is again from High Court, that the officer responsible were basically was penalized personally for a sum of rupees 50,000 rupees, and the
Hmm.
claim was rejected. So one thing which is very clear, that in case the entire process is over and the any organization or any person has not filed their claim, so that actually means that the claim would be completely considered as invalid after that.
So these days also, when the insolvency starts, then PF starts an inspection after on the occasion of CRP initiation. That has happened to many of our cases also. And then they file a claim within 90 days because within 14 days they're normally not able to complete the inspection part.
Yeah. Now, of
So
course, the claims can be filed like RP has the power to deal with a claim before the release of RFRP
hmm.
and after the date of RFRP, but before the resolution plan is put to vote, RP collectively with the COC has the power to admit or reject a claim. And in case the RP and the COC both are accepting a claim, then one consolidated application will be submitted by the RP before the adjudicating authority for condonation of all the delays, wherever they have accepted the claim.
Then question from Mr. Rajiv Mokin. He says your views in ERA Infra Delhi High Court case. There's another question that you can answer simultaneously, perhaps, is from Mr. Ranjan. He asks whether Supreme Court has allowed this detachment by ED in any of the cases.
One, that the Supreme Court has still not allowed any such case where the attachment has been detached under IBC. The Supreme Court has is keeping all these cases pending. Whereas there are cases, in our case, like in the case of Nirav Modi, which we are handling, where we are the liquidator, and we, in fact, the bank made an application to special courts under PMLA, and the special court under PMLA accepted the claim of the Punjab National Bank, and the assets were released. Now the assets are being handed over by the Enforcement Directorate to us, the liquidator, uh, but the Enforcement Directorate has not filed any appeal.
No, but here
So,
it was also an announcement from the government that we are deattaching these assets and DNB to get this kind of money through the liquidation of these assets. So that was also with an announcement from the government.
so that was the intent of the government. Like one, the money belongs to public sector bank, and the government wanted to support public sector bank, that whatever money you could recover, you can recover as fast as possible. So the government did not file any appeal against that special court order. Similar order was passed in the case of Mehul Chokthi also, but in that case, the Enforcement Directorate filed that appeal against the release of assets to liquidator. Because in the case of Mehul Chokthi, again we are the liquidator, so we also have seen that in that case the appeal was filed, but in the case of Nirav Modi, where the public sector bank was involved, the appeal was not filed by the Enforcement Directorate. I will come to the IRA infra in some time, so that we can keep that question pending. That is a judgment which is covered in my deliberation today.
So one more question from Mr. Vipul Dubey. He says, what will be the outcome as per PMLA attachment? The property attached is subsequent to creation of mortgage with financial creditor, and CIRP has started subsequently. Will the FC be allowed to sell the attached property in liquidation if not relinquished?
So the merits of the case that we are arguing before appellate tribunal under PMLA, called appellate tribunal under SAFEMA also. What we are trying to argue is that, number one, that there is a period of crime in the FIR or in the enforcement case information report, ECIR. ECIR is a private document, and the charge sheet is something that is given to us. ECIR is not even given to the court. But the charge sheet, when the charge sheet is given to us, we normally see what is the period of crime, and what is the amount of proceeds of crime. So these two things are the first thing that we see. And then we see the merits of our case. In case the acquisition of the asset is much before the proceeds of crime or period of crime, or the mortgage of the asset is before the period of crime, then we always say that these are not the assets which are acquired out of the proceeds of crime. So therefore, the kind of money laundering law is not applicable, because these assets, in fact, was available with us. It was in our possession. It was in our ownership much before the period of crime. However, the ED is presently, there is an issue which is pending, that in case the ED see that there is some properties which have been acquired out of the proceeds of crime, and those properties are beyond the reach of enforcement directorate, maybe because of the jurisdiction, foreign jurisdiction, some assets which actually have gone out of India, then they are also saying that we have the power to attach almost equivalent assets in India, in case we are not able to recover those assets which are in foreign jurisdiction. So therefore, they are in fact continuing with the attachment, even if the assets were acquired or assets were mortgaged much before the period of crime, or the assets were basically acquired out of the direct loan taken from the banks. So that issue is also pending before the court, like whether that is a valid reason given by the enforcement directorate or not. Yes, Ankit.
We have a question with respect to, yeah, that's about it, taken care of.
So I can even now go to some other judgments, And I was saying, the question of law, uh, which is presently in various cases of high courts or ANCLAT, which are pending before Honorable Supreme Court. And the question of law are basically whether the PMLA and IBC are parallel proceedings, criminal proceedings, or there are two parts. One is a civil part, one is a criminal part. Then the Enforcement Directorate has the power to attach properties uh, of equivalent value, equivalent to the proceeds of crime, and whether the burden of accused is on the accused is to refute the claims or not. Also, the PMLA overrides the laws concerning money laundering and proceeds of crime, but coexist with the Recovery of Debt and Bankruptcy Act, SURFACI Act, and Insolvency Law. The third party claims require evidence of lawful acquisition and compliance with relevant laws. Prior charges by secured creditors do not automatically render attachment illegal. Prior charges by the secured creditors do not automatically render the attachment illegal. Their release depends upon bona fide. Attachment under PMLA are subject to satisfaction of prior charges or encumbrances by third party claimants. Excess value accountable to enforcement authorities in cases of third party claims. Special courts adjudicate claims of bona fide third parties' interest once attachment orders are finalized, confiscation orders are issued, or trial proceedings commenced under PMLA. In this these are various issues which are pending before Honorable Supreme Court, and all these, whatever I read, these was the observations of Delhi High Court in the case of Axis Bank versus Deputy Director, Enforcement Directorate. Coming to the other connected matters is the Rotomac Global, where we invoked Section 32A, and of course we could not sell the assets because the assets were attached, but the ANCLAT in fact dismissed, and ANCLAT dismissed, and the basically ANCLAT held that Section 14 of the IBC does not apply to proceedings related to criminal actions or penalties under PMLA. This was held by ANCLAT in Rotomac, which is my case. Then penalty under PMLA applies to individuals, including ex-directors and shareholders of the corporate debtor, and they cannot seek protection under Section 14 of the IBC. Similarly, the attachment under PMLA were made before the initiation of CIRP, hence the RP cannot be benefited from Section 14 of IBC. PMLA operates in different field of penal action and runs concurrently with the IBC without one act having overriding effect over the others. So this was the held portion in the case of Rotomac Global Private Limited versus the Deputy Director of Enforcement. The other matter which is attached to this Supreme Court pendency is the ARCIL versus Deputy Director. ARCIL versus Deputy Director, and another case is Viceroy Hotels Limited versus Deputy Director. So these are basically the same case. One actually is ANCLAT and the other is the application which is pending before the Honorable Supreme Court. So there are two citations. One is the case of NCL80, which has gone to Supreme Court, and the other is what is the citation given by the Supreme Court. However, the case is pending. So ARCIL versus Deputy Director, and the NCL80 was the Viceroy Hotels Limited. And in this case also, this Madras High Court order Deputy Director, the Deputy Director of Enforcement Directorate, and Madras High Court held that NCLT has got no jurisdiction to go into the matters governed under PMLA. Another matter which is tagged together before Honorable Supreme Court is PNB Housing Finance Limited versus Deputy Director, and that actually is a judgment which is from Punjab and Haryana High Court, and Punjab and Haryana High Court had held that PMLA would prevail over SARFAESI Act. So PMLA would prevail over SARFAESI Act, PMLA would prevail over RDBA, PMLA would prevail over insolvency law. So these are the judgments, and another judgment which is tagged together is ICICI Bank Limited versus Deputy Director Enforcement, State Bank of India versus Deputy Director Enforcement, and the resolution of RP of the Diamond Power Infrastructure Limited versus Union of India. RP of the RP for Diamond Power Infrastructure Limited versus Union of India. So this is another judgment, and one more judgment which is tagged together is the consortium of GSEC. Consortium of GSEC Limited versus Rakesh Shah versus and Rakesh Shah versus Union of India, and Government of India, Ministry of Finance versus HDFC Bank Limited. That is also another judgment. So the total 9 judgments which are presently tagged together. Now we have another judgment which is again from our partner Vinay Kumar Sangania, and the name of the judgment is Vinay Kumar Sangania versus Directorate of Economic Offense. So, like, I'm actually very happy to see that most of the judgments, like many judgments of PMLA versus ED, basically having where the largest role is from AAA, like in the case of Rotomac Group, in the case of REA Agro, in the case of Varsana Ispat, in the case of Diamond Power, in the case of Pincon Spirits, where the Vinay Sangania, and in the case of even PSL, where Nitin Jain is our partner, Vinay Sangania is our partner. In my cases, in the like Nirav Modi, all cases, Mehul Choksi, all cases. So all these cases, in fact, so therefore we understand the PMLA versus IBC to a great extent. And in this case, which is Vinay Kumar Sangania and Supreme Court of India, that is the judgment which is pending. And the next date is again April 2024. Now, the order against which this appeal has been filed, that is basically Directorate of Economic Offense. This is not an ED case, but this is a Directorate of Economic Offenses versus Vinay Kumar Sangania, and the corporate debtor name is Pincon Spirits. So in this case, in fact, basically, again, like we have seen the Maharashtra protection of interest of depositors, one judgment that we have seen, and the other judgment is this is the West Bengal protection of interest of depositors. And the West Bengal protection of interest of depositors is again a case where the Department of Enforcement, like the West Bengal Department of Enforcement and Offenses, economic offenses, like the Department of Economic Offenses, in fact, attached all the properties, and the properties were attached under West Bengal Protection of Interest of Depositors in Financial Establishment Act. And then the claim, so in this case, the NCLAT in fact held that this West Bengal Protection of Interest of Depositors Act deal with fraudulent deposits accepted by the companies and imposes penalties, including imprisonment, on individuals responsible for such defaults. And Section 3, Subsection 2 of this Act stipulates punishment for individuals involved in the fraudulent deposit defaults, irrespective of their association with the corporate debtor. Section 14 of the IBC, which imposes a moratorium on legal proceedings against the corporate debtor, does not apply to criminal proceedings or actions stemming from criminal acts such as those under West Bengal Protection of Interest of Deposit Holders. Properties of these corporate debtors were attached, and its office was sealed, and that was sealed before the initiation of CIRP. No resolution plan was approved in this case. Immunity from prosecution is not extended to the corporate debtor, and therefore this West Bengal Protection of Interest of Deposit Holders, they actually provide a legal recourse, and can file an appeal to the High Court of Calcutta. However, see, the the NCL80 also held the same way. NCL80 says that the moratorium has been declared after the properties are attached by Department of Economic Offences and West Bengal and produced before the designated Court of Economic Offences. Thus, Section 14 of the IBC has no overriding effect on Section 3 of the said decision was challenged by the RP before the Supreme Court. So first, the RP lost from NCLT, then RP lost from NCL80, and then the matter is pending before Honorable Supreme Court, and that is a matter under the West Bengal Protection of Interest of Depositors. So that is another very significant matter which is pending before the Honorable Supreme Court. The Nitin Jain judgment, in fact, I have already deliberated on that Nitin Jain judgment. So I would actually be now focusing on this Bhushan Power and Steel Limited. In the case of Bhushan Power and Steel Limited, Mahinder Kumar Khandelwal versus Directorate of Enforcement, this judgment is also from Delhi High Court, and this is 31st of January 2024. 31st of January 2024, and the facts are basically the IRP was appointed, the resolution plan was also approved by NCLT, so the company was in all set for taking over by JSW Steel Limited. And in the meantime, fraud was committed by the ex-promoters, and the CBI registered an FIR also. So during the CIRP also, the RP cooperated with the investigations, and the search was also conducted on the RP side. So, or basically, like all these properties, all these assets, all these documents were in fact seized by the Enforcement Directorate. Delhi High Court in case held that uh, the court held that the proceedings relating to any offense under PMLA has to mean proceedings filed before the special court in relation to the property or the record so attached, seized, or frozen. ED was directed to return the documents, digital devices, property, and other material seized from the petitioner pursuant to the search and seizure operations. And that was the order of the Honorable Supreme Court in the Honorable High Court in the case of uh, Mahinder Kumar Khandelwal versus Directorate of Enforcement, and the corporate debtor in this case is Bhushan Power and Steel Limited. So going forward, we have another case which is again from Delhi High Court, that is Talib Hassan Darvesh versus Director of Enforcement, and in this case the name of the corporate debtor is Technova Plastic Industries Private Limited, and this judgment is as latest as 13th of March 2024. So in this judgment, in fact, Technova received a term loan, and then the company was declared NPA. Then NCLT Ahmedabad admitted CIRP, and then the Bank of the search also took place. Summons were also issued, and the enforcement the applicant, the petitioner, in fact, petitioner, the petitioner wanted that the ED investigation may be stayed and no coercive action be taken. So Delhi High Court, in fact, uh, ordered uh, that the quashing of summon issued by ED is not justified merely because specific documents are not specified in the summons, as the PMLA allows for investigation into proceeds of crime without disclosing evidence at the summons stage. Reference to NCLT and court orders in insolvency proceedings do not absolve the petitioner from association with proceeds of crime or negate ED's jurisdiction to investigate in summons. So therefore, this process continued, the summon continued, no stay was in fact given. At this moment, Ankit, since we have the last 5 minutes, can we have some questions if there are?
So, the There is a question from Mr. Maharaj Kumar. He says that he wants us to appraise the jurisdiction of EOW and ED.
Now, see, the economic offense wing is there in all these states. Economic offense wing is the Department of State Police. It is under the state government. It is not under the central government. Now, when we go to the RBI circular regarding the frauds in bank, and that may be a fraud by the borrower, it is very clear that if the fraud amount is more than 50 crore, then it will go to joint director, CBI. And if it is less than that, then it will go to deputy director, CBI. Now, when the CBI is doing the investigation, and in case it is below that, then it goes to economic offense wing of it. Then it goes to economic offense wing of the state police. When the CBI is doing this kind of investigation, the CBI thinks that there is at least one section which is being contravened out of the scheduled offenses under PMLA. So the PMLA has the scheduled offenses that if the offense is under these sections, then the PMLA can be invoked. So once the PMLA is invoked, so the investigating authority under PMLA is Enforcement Directorate. Adjudicating authority under PMLA is separate. Appellate authority under PMLA is separate. So the investigating agency under PMLA is the Enforcement Directorate, and investigating agency has the power to arrest and power to seize and attach assets. Yes, Ankit.
So then the second question that we have is like that's from Prashant Ji. Prashant Ji says that whether in case of provisional attachment after initiation of CRP, whether apart from contesting the same before the AA PMLA in the SCN issued by it, is it also advisable to file an application before NCLT for removal of provisional attachment, or do you think that it's pretty clear that NCLT will have no role to play in this whole process?
No, considering the judgment of Shiv Charan versus adjudicating authority under PMLA from Bombay High Court, most of the jurisdictions in Maharashtra would definitely help, will kind of use this judgment to give orders. Section 32A is very important whenever we talk about detachment under IPC. So in case we are able to show that the resolution plan is approved or the assets are sold, and the resolution applicant, successful resolution applicant is also assuring that it is a change of management, and the successful resolution applicant is not even accused in the charge sheet. Then after doing all this, then there is a jurisdiction before NCLT to approve the resolution plan and also to direct the ED to detach the assets. That is only in case 32A is complied with. Moratorium is not helping, but 32A is helping, but that is helping only in those cases where the resolution plan has been approved. After that, it is applicable. Yes, Ankit.
So then we have a question. So there's a question that what is the perspective, or what should be the perspective of the PRA? What should be his point of view when they are filing a plan where assets are attached under PMLA? I think it's a very, very relevant question that, when somebody is filing a resolution plan, what should be part of that resolution plan to take care of the ED matters so that it supports the whole regulations and it increases the chances of getting the assets detached at a future point in time,
So
or
I think
rather de-risk.
we have done an experiment in one of the case. I will not like to take name, where we have actually we had started the process of sale of the company as a going concern in liquidation process, and we also said in the document that this sale is being made subject to the detachment by Enforcement Directorate under PMLA. So we sold the asset duly attached by PMLA. It was very, very clearly mentioned that the assets are duly attached. We also got an approval from the committee of creditors that after the payment of 30%, we will hand over the charge of the assets to the successful resolution applicant or the buyer in the liquidation process. Then we will apply to NCLT and invoking section 32A. Now, the committee of creditors is otherwise not having any option. SRA will give 30% and will take a risk. And in the meantime, we will go to the court that once the detachment is done, the balance amount would be paid. That may work according to this Bombay High Court. That may work because in case someone can try getting a plan approved under and then invoking 32A or selling the assets as a going concern or in piecemeal and then invoking 32A and like complying with the conditions of 32A, like the change of management and the acquirer would not have been accused in the charge sheet. If these compliances are made, then probably section 32A would be used and this Bombay High Court judgment in the case of Shiv Charan would be relied upon. That is the only way forward as of now, unless the Supreme Court decides something otherwise.
So that's about it then. I think we are also over time, so we can
So in
close.
fact, there are many judgments and many judgments to the extent that there are many NCLAT judgments and there are many NCLT judgments. So we can actually conclude, one, that moratorium benefit is not given. Number two, the adjudicating authority has no power to simply detach. Adjudicating authority has the power to approve a resolution plan subject to detachment by the appropriate authority. Then High Court can detach, and that is what is the present applicability of the law. We have in fact worked hard. In fact, there are 20 more judgments that we have. And in fact, many of these judgments I have taken from a new book published by Vadwa Law Chambers. And the name of that book is PMLA, Practice and Law, and also the Proceeds of Crime. And their latest version, which is 2024 version, is also has given me a lot of judgments. And even those judgments also which are not even reported. So I definitely say that this book has helped, but the time is short, so I'm not able to deliberate through all the judgments and many judgments from NCLT which are conflicting also. But I can say the latest trend is basically this Bombay High Court. The latest almost finalized concept is that the section 14 cannot be used, and also the detachment powers are not available with the adjudicating authority unless section 32A is applied. So this is what we can conclude. And as we always say, that this is our way of learning and there is no other objective. I would also request all of you to subscribe to our YouTube channel, which is AAA Insolvency, so that you get the alert whenever a new video is uploaded there. Thank you from my side. Okay.
Thank you, everyone. Thank you so much.
Thank you.